Dear friends, in today's discussion, in this video, I'm going to talk about the article published by Hindu and authored by Justice Anand Venkatesh of Honble Madras High Court. This article is based on the property, the right to property. As we all know, the right to property was a fundamental right. And then it was shifted to 31A. Became later it became constitutional right. Now, when fundamental rights are violated, the state is bound to pay compensation. So, how this compensation, the word which changed from compensation to an amount, the honorable judge discussed very well. Learned Judge Anand Venkatesh, a series of video lectures is giving for students. They are very useful. I am a teacher for almost four decades, and many times I heard most of his lectures. Every lecture you can remember the way he communicates the most complicated subjects. I'm really excited. I love it. Many times I read. Of course, I keep reading all the top judges, so everything to learn. But his communication abilities, like as a teacher, I feel are very useful to the students. Now, this article, I think many of you would have read, and let me take how he built the entire narrative so simply. The 25th Amendment, 44th Amendment, 4th Amendment. Finally, he came to the conclusion how the tussle between the parliament and the judiciary, by way of parliament, by way of social objective, they want to promote the social objective of the government of the day, whereas the judiciary would like to safeguard the interest of the people in property. My interest is heightened in this particular article is because Article 21 is violated, then you will get a compensation. The public law remedy, where there is a common law remedy is also there, that civil suit you can file. But then over a period, the Honorable Supreme Court increased the scope of the compensation. Honorable Justice S. Manikumar on Madurai bench as a single judge, in one case, he analyzed the concept of compensation. Now, that if you see Article 21, it focuses very much on the police custody, torture, death, custodial deaths, and those things. And only in the case of even Bhim Singh, we have seen where that he was incarcerated, and then 50,000 was valuable right of voting. When the state instrumentalities are induced through their mighty power, exercising without justice, it's become tyrannous. So on that count, 21 is 21. Right to life is the precious of the most precious fundamental rights, but that is focused on police atrocities or electricity. When the electrocution takes place and somebody dies because of this state negligence. But now I am trying to build it into loss of reputation. That is why I am very much interested in this article. At the right time, I got it. See what happens today in the social media, or everybody wants to tarnish your image. And our mind always receives the bad news and retains it. And always human beings by nature, if you see, they enjoy talking ill of somebody else. You can see how the trolls, you can see where Anand they are called. The way they were trolling Rahul Gandhi, nobody would have taken it, but he took it and proved himself. So today, the violence, the people's in the thing has gone up. If you are doing something good, they would like to attack you with all the might. And one is the social media. And the goodwill that you have built in over a period of time, hard and honest hard work will be destroyed in no time. So therefore, I want to bring right to reputation is also part of right to, that's already there. There is nothing that I'm doing, but rather the compensation, because there is civil remedy is there for civil defamation, and criminal defamation is there for 99. That apart, writ jurisdiction also 226 has to be invoked. And those jurisprudence of that law, for analyzing that law, we have a judgment of Honorable A.K. Ramakrishnan of Madurai, Justice Ramakrishnan of Madurai bench. It was a beautiful judgment which we have recorded on the importance of reputation as a fundamental right. The lordships have analyzed it beautifully in that judgment. And added to this constitutional flavor is being given to this case. So let us take the PowerPoint presentation that I have put before you, all of you. And I'll screen share it. Right. It's a very good article. Every student must go through. And as you know, we have almost 100 plus colleges. All the principals are very kind. And they are receiving this as more like a moot courts that we are building up. And I suggest the video lectures of this honorable judges are highly interesting. And quickly you can grasp you see the way in which he presented this. Property is real, and so should the compensation. So that word compensation is highly interesting. That is under Article 226 of our Constitution. John Adams says, President John Adams, property is surely a right of mankind, as real as liberty. As real as liberty. You understand? Right to life, right to freedom of speech, liberty, etc. The fundamental rights. The right to property, initially envisaged as a fundamental right and later as a constitutional right, has witnessed an interesting history in the post-colonial era. No other right as enshrined in the Constitution has witnessed a tussle as fierce as between courts and the legislature. The narrative starts from 1955. The genesis of this power struggle dates back to the case of Bala Banerjee. Lordship, you can see, Bala Banerjee, though when it was 1901F as a fundamental right, the protections, see, violation of fundamental rights, compensation under Article 226, you will get. But a constitutional right, fundamental right is different from constitutional right. This is under Article 300A of the Constitution. So how it is built up, what is the narrative as on date, up to that, Lordships have come. So 19(1)(f) and 31(2) of the Constitution prior to the amendment. The Supreme Court of India held that the word compensation in Article 31(2) postulated a just equivalent of what the owner has been deprived of. A just equivalent of what the owner has been deprived of. To undo this interpretation, see, when that interpretation is there, equivalent what the owner has been deprived, right? You have to be quantifying it is money and money's worth, valuation, right? If you see I'll come to that point. If you see in a balance sheet, the goodwill, the reputation of the company will be valued much, much higher than the tangible assets. Goodwill is an intangible asset. Reputation is an intangible asset. It can be valued based on that. We can come back. To undo this interpretation, the Constitution 4th Amendment was passed in 1955, amending inter alia Article 31(2) to expressly state that the courts could not delve into the question of inadequacy of compensation. So, through the process of they very made it clear that whatever government says as compensation, you please see whether it is given. And you have no right to go on interpreting it whether it is adequate or not. So, then came the courts are, you see, interpretation. We have 3 state organs, executive, parliament, legislature, and then judiciary. The parliament is entrusted with the process of legislature producing laws. and the executive has to implement them. And the judiciary is confined to interpretation of the law enacted by the parliament. But through the process of interpretation, the judiciary will be able to make the other state organs like executive and legislative to confine to themselves. That's why we have a basic structure. So judiciary is ultimately more powerful. And Justice Holmes in Kilburn and Thompson's case has said that justice without power is inefficient, and power without justice is tyrannous. That is, therefore, judiciary is dominant. Among the three state organs, though everybody argues, no, what do you do? Judiciary has to be. And if you see the parliament discussion in the case of judicial review power, whether to give to the parliament or to the judiciary, the power of judicial review, particularly because parliament represents the feelings of the people, and how one or two judges having their own prejudices by way of interpretation can remove that or distort it. All that we know. But we came to know Constitution is amendable, amendment of Constitution, but within the phrase a law enacted under Article 13(2) is subject to these things, but then it should be within the basic feature of our Constitution. That will come back later. So now to retaliate, the courts then devised an ingenious plan. They held that although the final compensation was not justiciable, the principles fixed by the legislature to arrive at such determination would be open to scrutiny. Okay, you are saying I'll pay you 10 lakhs, 5,000, 10,000. How are you coming to arriving at it? How are you arriving at it? We have seen in Ram Janmabhoomi, the way in which the government bulldozed the entire people have lost everything without compensation. In the name of Lord Ram, the symbol of dharma, compassion, Daya Sindhu, the government went on just like that, unmindful of the feelings of, even you hit one person. See, when you are in judiciary or top positions, you have no right to do injustice to a single person. You cannot say you have chosen that and you have to do the justice. In the Dharma Shastras, if you see, a judge should always be learning. Continuously is in the process of learning. He should be unbiased, impartial. And if anything goes wrong, a loss, 30 times the king has to compensate the loss suffered. That is how the Manusmriti started. Then Arthashastras come. We will take up on another day. But to retaliate through the process of interpretation is the wild power given to the judiciary, which needs to exercise it. Word substitution. Parliament, for its part, realized that the word compensation, Article 31(2), was source of all mischief. Then 25th Amendment Act, the compensation was substituted by the word amount, which kept the interpretation of the courts at bay. Thus, the acquisition of property could now be effected through the medium of eminent domain, the estate, by paying the landowner an amount as distinguished from compensation. The adequacy of such amount was consequently not open to judicial review. Though the validity of the Constitution 25th Amendment 1971 was upheld in Kesavananda Bharati, the Supreme Court watered down the intended effect of the amended Article 31(2) by interpretative process. See, at that point, the government is a social justice. You can't have jamindars having too much of property. And so the government can take over the property. But what is the adequate compensation? Compensation, adequacy is tested, equivalent amount. But amount means what you determine. Then the question came, the process of interpretation. How do you determine that? That principles behind that should not be arbitrary. The majority in Kesavananda Bharati took the view that though adequacy of the amount paid was not justiciable, the court could still examine whether the principles fixed for determining the such compensation were relevant, which in effect reinstated what Justice Shah had said in the bank nationalization case. After this decision, Parliament was convinced that the right to property remained a proverbial throne in the goal of achieving the socialist state. This was because the right to property, from a socialist point of view, was very much citadel of the. Now, what happened then? You see that 44th Amendment, they thought it's becoming a nuisance to keep that 91F, right to property, as a fundamental right. And then let us remove from that and keep it as a constitutional right under Article 300A. Article 31, which had witnessed much controversy in the matter of the determination of compensation, was also deleted. The ripple was felt instantly. Justice K.K. Matthew, who was one of the dissenting judges in Case 1 on the observed that ownership of property has a direct correlation to the quality of civilization and its culture, and hence opined that there is no justification to exclude the fundamental right to own and acquire the property from the category of basic features of Constitution, even if it be assumed that the concept of basic structure is a tenable one. So we all have to, I just want to recollect, in Gopalan's case, when the question of fundamental rights, Article 21, freedom of life, liberty, was discussed, then the majority took the concept that the principles of natural justice is an abstract concept. Now, but then we have seen Fazil Ali, and he said, what is natural justice is a divine law. It is inbuilt, ingrained into all the laws. You don't need to say there specially. Otherwise, you are having a law, a law as enacted by the Parliament, and then you empower the police official to shoot the person. If he complies with the provisions, you will kill the person. Freedom of life, precious of the most precious fundamental rights. So therefore, they needed, whether it is a due process or a fair process, justiciable. That's why they have very clearly said, when the state, you are testing the state against Article 21, it is the state which should come clean, whether the process is tested under fairness. There is no arbitrariness. Checks and balances should be there. If it is freedom of Article 19 violation, then it should fall under the reasonable restrictions. Under 14, then it should not be arbitrary. So therefore, in that lines, this was discussed. And Professor P.K. Tripathi wrote an influential article arguing that the deletion of Article 31 was folly, and further that the power granted by entry 42 of the current list is the power to acquire and not the power to confiscate. Confiscate means power is used without justice, and then acquire is power is used with justice. And as long as these two conditions, namely the acquisition can be for a public purpose only, and that the acquisition must be accompanied by compensation, were expressly incorporated in the provisions of Article 31(2), it was not necessary, perhaps not even permissible, to invoke them as inherent parts of the granting relief. Article 300A reads that no person shall be deprived of his property save by authority of law. This, according to Professor Tripathi, still meant that law cannot be valid unless the acquisition or requisition is for a public purpose, and there is also provision in the law for paying compensation. In that sense, he believed that compensation will continue to have the same meaning given in the case of Bela Banerjee, namely, which is the market value of the property concerned at a time not too much remote from the date of period of acquisition. In the years that have followed the deletion of Article 19(1) and 31, the Supreme Court has held that the right to property is not only a constitutional right, but also a human right. This is where I want to build in right to reputation into Article 21. In the case of Mehta, the Supreme Court held that to be a valid law, it must be just, fair, and reasonable. In other words, through the right to, though the right to property was not a fundamental right, a law which deprives a person of his property must answer to the requirements of Article 14, 19, and 21. In B.K. Ravindra, the court went a step further and observed that phrasing of Article 300A has a striking resemblance to Article 21 and 265, that is the concurrent list, and hence is a guarantee would not be read down. Passages that are protected. That's what Lordship was trying to explain. Even though you are removed from the fundamental rights, but still the same protection, if not better protection, is available even under a constitutional right when you are not expected to have it. The recent decision of the Honorable Supreme Court in Kolkata Municipal Corporation has fleshed out 7 different facets which are protected under Article 300A. These are right to notice, the right to be heard, the right to be a reasoned decision, the duty to acquire only for a public purpose, and the right of restitution or fair compensation, the right to an efficient and expeditious process, the right of conclusion. The court has concluded that the absence of even one of these features would render the law susceptible to challenge. The right to restitution or a fair compensation, judiciary affirms that the position prevailing when the unnamed Article 31 was in force. And the interpretation expounded in the Bala Banerjee case as the aspect of payment of compensation. The person deprived of land by a state in exercise of its power of eminent domain is entitled to be paid a compensation which is just and reasonable. The court in Kolkata Municipal Corporation has reiterated that deprivation or the extinguishment of that right is permissible only upon restitution, be it in the form of monetary compensation, rehabilitation, or similar means. Thus, the requirement of paying compensation, that is, money's worth of the property acquired, which was the original position in Bala Banerjee's case, has now been reinstated. The wheel has come full circle. It's a wonderful article, and now we have to build it, because the changed circumstance constitution is an organic document, dear friends, and it has to be, when the contribution, the constitution is an organic document, and therefore we have to provide for better safeguards by bringing it into the Article 21, the right of reputation. Because today everybody is tarnished. That's called trolled. And by attacking any person who is having more cases, that means honest person. That is what you can come across. So thank you.